Good evening. My name is Stephanie Balmer with the Falsani, Balmer, Peterson, Quinn, and Beyer firm. We're here tonight for the wills and estate planning probate episode of the show. What should we all be doing right now to realistically prepare for the end of our lives? It may feel overwhelming, but these days, even your primary care physician wants to know if you have a will. We're talking about estate planning and probate tonight on Lawyers on the Line. Again, I'm Stephanie, an attorney with the Falsani, Balmer, Peterson, Quinn, and Beyer firm, and this evening's moderator. I'm pleased to welcome our panelists, Mark T. Signorelli of the law firm of Mark T. Signorelli Limited, Jennifer Carey of the Hanft Fride law firm, and Amy Kuronen of the law office of Amy Kuronen. We're ready to take your questions. Call us locally at 218-788-2844 or call our toll-free line at 1-877-307-8762. And now let's get on with tonight's topic. The first question we have is a softball, we'll call it. Mr. Signorelli, or Mark, how often should I update my estate plan?
Well, it's one of the best DIY projects you can have, and each year you should have an at-home file of what you have done. And each year at a given date, such as a Thanksgiving holiday, you should look at your own file. What has changed? Then do we need to call a lawyer to make any changes? But it's a simple at-home DIY process. Once a year is good enough.
And I would add, Stephanie, that if any of your clients are like some of mine, they're big procrastinators. And so to ask them to do something once a year, even though it's an excellent goal, might not happen. And so I think that as long as they think about what has changed, those big life events like birth, death, marriage, divorce, those are really good times to say, oh, I need to look at my estate plan too.
All right. Here's another question that I'm sure is at the front of many people's minds. Amy, what happens if there is no will and someone passes? For example, Prince.
We were talking about this a little bit before the show. There are several things that can happen, and it depends on the nature of the person's assets, the assets that he or she has, and it also depends on their family members. For example, some assets are going to pass by beneficiary designation, a life insurance policy, for example, or a retirement account that has beneficiary designations. Some assets are owned in joint tenancy, and those will pass automatically. Where the problem comes in is assets that might just be in a single person's name. For example, if Prince had a bank account just in his own name with no beneficiary tied to it, at that point the Minnesota statutes come into play, and the Minnesota statutes will set forth who will inherit that money.
So there's some structure in place independent of a family or an individual consulting with a lawyer and drafting up the documents. The courts will still take action to direct what happens with a deceased asset.
That's correct. It just won't necessarily be what the deceased may have wanted to have happen.
Okay. We have a question from a local caller who inherited a large amount of money last year. Everything has since been converted to cash. She's still waiting for the money. She's wondering if she has to hire an attorney to get the money from the estate.
Well, she shouldn't, and it's personally dependent on the timeline that's involved. Estates don't settle quickly or automatically. There's a period for creditors. There's a period for the filing of tax returns, a period for accounting. But the chief burden and duty of an executor is to keep people informed, to talk to them. Here's where we are. Here's why it isn't finished. A partial distribution may be possible, but the court will ultimately approve a final account and a final distribution.
Okay. We have a caller who owns their own home and lake cottage. Their 4 children are beneficiaries. The caller wants to know if we can recommend a plan to keep peace in the family. Jenny, what do you think?
A plan to keep peace in the family, with particularly in the Northland, often has to do with that lake home or vacation property, because especially mom and dad often have spent many years with their family. happy memories, and they'd like to preserve that property for the next generation. So the two most common tools that we use are a cabin trust, as it's called sometimes, where the property can be held in a trust for the benefit of the children or other beneficiaries. And sometimes we use a limited liability company or other corporate entity to hold title to that property, and then the different family members have rights just like a shareholder in a corporation. But what I can tell you in my experience is that even when you use these tools, transferring that property to the next generation truly can often be a very difficult task. If you have 4 children who all enjoy it to the same degree and all are financially capable of contributing, that's your best case scenario for success.
Okay. Amy, here's a question from a local caller. Can a person execute their own transfer on death? Would it be legal?
Well, I'm wondering if is the caller asking, are they able to set up a transfer on death deed, for example, for real estate, or for transfer on death can apply to certain accounts, certain investment accounts, payable on death designations with regard to bank accounts and so on. Executing it means to sign it, and certainly they can sign it, and there may or may not be witness requirements. In fact, I really don't think there would be for the real estate type of transfers. If they're asking, can they set this up on their own, they certainly should at least talk to the financial institution, someone knowledgeable within the financial institution with regard to any type of transfer on death designation for a type of financial account. And they really should talk to a real estate attorney if they are looking at doing transfer on death for real property.
And one of the problems of the transfer on death is the wrong person dies first. Mm-hmm. Like in a joint tenancy, you assume your son is going to receive an account, except that he dies first.
Correct.
Now it's back in your name and it's a probate asset.
I would say too that a transfer on death deed in particular with respect to real estate is something relatively new to Minnesota and is now being offered in other states, increasing almost every year in terms of its availability. And on its face, it's a very simple, easy thing to do, and you're tempted to say, yes, you could do that by yourself. But the reality is that even though it looks simple, it can't be done without, or it shouldn't be done without taking the rest of your estate plan into consideration. So if you call a lawyer and you say, I just want to do a transfer on death deed, how much will it cost? Because of these other concerns, that's why you might get the answer from the lawyer, well, actually it depends, and can we talk about the rest of your estate? Interestingly enough, though, particularly with the popularity of the transfer on death deeds for real estate in the legislative session this year, there is a bill pending to allow transfer on death with respect to boats and motor vehicles. And so if that legislation passes, you'll be able to do that not only with your bank accounts or the real property, but also with things like boats and cars.
All right. Another caller has identified a sister and a brother as beneficiaries to a trust that's held in a bank. The administrator of the trust refuses to talk to them without an attorney. I'm not sure if it means they need an attorney or the bank needs an attorney. What are the requirements in terms of legal relations? I'll start with you, Amy.
I can maybe answer that quite easily. I used to work in a bank trust department, okay. So I'm familiar with that. Of course, not knowing the exact circumstances that are at play here, it may be that the bank is not able to talk without an attorney because there is some type of litigation going on, and the trust relationship manager, the trust officer, just does not want to be or cannot be in a position of saying something wrong or without an attorney present. If they are saying that, so that's one likely scenario as to why they would want an attorney present. Otherwise, I can't quite picture an exact scenario where they would require an attorney present. They might think it's best to just have a third party over participating in the conversation to make sure that everybody is on the same page and hears hears the same thing and understands it after the fact. I could see that as a possibility.
An abundance of caution.
An abundance of caution,
All right.
exactly.
We have a question from a caller in Wisconsin. Is anybody licensed in Wisconsin here?
I am.
Yes.
I am.
Is there a way of titling your land in Wisconsin so that it passes on death without going through probate? Mark?
Well, they do have a Wisconsin transfer on death deed.
Okay.
Wisconsin also has perhaps a benefit, perhaps a complication, community property. And so if you have community property and only one of a husband and wife want to do it that way, they can only deal with half interest in the property.
All right. We have a caller from Tower. He was cohabiting with his now current wife when they purchased the home in joint tenancy. So they weren't married at the time. She is currently in managed care. What happens when either of them dies? Does that affect the passage of the home, I guess would be the question. Jenny?
When they say managed care, I guess one of my questions would be, is she receiving public benefits such as medical assistance to help pay for that care? If the property is still in joint tenancy, her half interest in that property could be subject eventually to a claim or lien for reimbursement for medical assistance or other public benefits paid. So often a smart planning idea is before that person becomes eligible for those benefits, we often recommend that they transfer their interest in the house to the other spouse, because that is a transfer that you can do without being penalized for it.
Here the complication is they weren't husband and wife, right?
I thought they got married though.
They did eventually get married.
Okay, I'm sorry.
Right, and so it sounds like this is a complicated enough issue that they would probably want to consult an attorney before conducting some of these transactions. We've seen that in the news lately, I think, around here. The trust or the state coming after property and whatnot after someone receives benefits, public assistance. Here's another caller question. How does a person get a living reversible trust? Can you create one yourself, or should you go through an attorney? Amy?
I think the caller is probably referring to what is called a living revocable trust.
Okay.
And they may mean reversible in the sense that they can get out of it at any time or change it, and that the term that we use is a revocable trust. I do recommend that a person contacts an attorney. There are certainly, Mark used the term earlier, do-it-yourself type of kits and online services. I think trusts are they're such a great tool, and they are so flexible. But you do have to be so careful in drafting them, and I think a mistake in drafting can lead to such unintended consequences that, of course, if it's reversible or revocable, it could be corrected later. But I think it's probably more cost-effective and efficient on the front end to work with an attorney to set up your trust.
That is a nice pathway into this additional question about a special needs trust. What about parents who have children with special needs or who are disabled? Mark, are you able to talk a little bit about the different types of trusts along those lines?
Well, there is a trust that's created with the assets of the beneficiary who is disabled. Let's say the grandparent died and didn't make special provisions, and this disabled child comes into funds. Generally, you have to go to court to get that trust established, and our our statewide Department of Human Services has made it a little more difficult in the last couple of years. The other is a trust that you would create for your disabled child, and again, there's a specific form and hoops you have to jump through. Do you put small amount of money in or a huge amount of money in, or because trusts themselves are taxable entities and they can only be used to pay for things that the government will not pay for. And so they may not get used from year to year. So it's a real balancing act.
Okay. Here's another caller question. Is a will testated by the spouse valid as the power of attorney? Let's start with testated. Jenny, what does that mean? I mean, when the when the caller is asking about if a will is validated or made authentic.
Well, in testate, intestate, they may be referring to what does it mean to die intestate. And if that's what they're asking, that means that they would die without a will. And in such a case, for assets, Amy was talking before about you might have assets that pass by beneficiary designation or with a joint account, for example. But with respect to the assets in that person's name alone, even though they don't have a will, they would end up in court to probate their estate with respect to those assets that they die holding in their name alone. And so some people think that if they have no will, that their money might go, for example, to the state of Minnesota, and they don't want that to happen. But actually, that's not what happens. The Minnesota statutes lay out for us who gets your property if you die without a will. So for example, if you think of next of kin, that's generally true, but the statute specifies exactly what that priority is.
Who counts and in what order?
Yes.
Okay.
Yes. And that's what Amy was also talking about. You can avoid that whole court probate process by having your assets in or going in to a living trust. That's a non-probate arrangement.
Okay. Say we have a will that's been attempted to be executed. What steps need to be taken to make sure that that will is valid? Amy?
Sure. There are legal requirements for a person to be able to have a will in the first place, or establish a will. First of all, they have to be over 18, I believe, and a competent adult. And then there are some signing requirements. And we were just talking about this shortly before the show. The will itself has to be witnessed, I believe, by 2 people. And I believe common practice, or I think the 3 of us would agree, a best practice is to have what's called a self-approved affidavit attached to the will, which is it's a very simple document, but it indicates that the person who is signing the will was competent, knew what he or she was doing, entered into the will voluntarily and willingly. And then that is witnessed by 2 people, and it is also notarized. And we believe that that's really the best way to go about making sure the will is valid.
Mark, what steps need to be taken when a business that is in a trust is mismanaged by the trustee?
Well, the trustee is liable. One of his duties is the duty of loyalty. And the trustee can be removed, and the trustee, perhaps in court, could be surcharged for the mismanagement of the business. That's a special proceeding against a trustee for inattention, mismanagement, those kinds of things. It's not a delightful file to get yourself involved with unless everybody can somehow come to an agreement, and maybe a mediated agreement regarding the business might work a lot quicker than going to court.
Okay. Jenny, here's a caller question. The individual has a home in a life estate for 2 children. The caller's husband died 2 years ago. His name is still on the deed. Does she need a lawyer to, I guess, take his name off the deed and put hers on?
If, for example, this is a husband and wife who had reserved a life estate for themselves and conveyed the real estate by a deed, giving what we call a remainder interest to the children. So they might think of that as putting their children's names on the deed. And although it doesn't currently work as effectively for this medical assistance planning we were talking about before, a number of years ago it was very common and very simple tool to use for medical assistance planning. So it may be that this caller's in that type of situation. And when the life tenant or one of the life tenant dies, it is necessary to remove their name from the title. And maybe it's something that they don't need to run right out and do, but if they were going to sell the home or refinance the home, it is certainly a requirement in order to pass clear title to the property. And what's required is called an affidavit of identity and survivorship. So it is a legal form. There is a uniform conveyancing blank that is available from the Department of Commerce that could be completed to accomplish that. But anytime somebody is filling out a form, even if it's a uniform conveyancing blank type of form, if they're uncomfortable about how they're completing it, are they doing it the right way, a lawyer could do that for them at a relatively simple price.
During the time, you mentioned that it wasn't necessarily something that someone would have to do immediately upon the individual's death. During the time that the form has not yet been filled out, is it an asset to the individuals to whom it has been left? In other words, the life estate, the individual subject to the life estate has now passed, and before the paperwork has been completed, the individuals who are now technically the owners, is that their asset even though the paperwork hasn't been completed?
Yes.
Okay.
With respect to somebody's death, when they own real estate, the remainder people, their interest will vest upon death. So even though the paperwork hasn't been taken care of, that they will be entitled to ownership of the property.
All right. This is a good question from a caller, Amy. When changes are made on an existing will, can you just cross things out and notarize them, or do you have to redo the entire will?
You do have to redo the entire will. You really should not cross out anything on your original will, and any changes should be subject or are subject to those signature requirements I was speaking about earlier.
All right. Mark, here's kind of a general question, and Jenny already mentioned a change that's probably coming soon. What are the big changes in the last 3 years regarding estate planning, if any?
Well, some of them are on the tax side. For example, people used to fear the federal estate tax a lot more than they do now because the exemptions have been going up and up and up. The federal fisc, as it is trying to get money out of the post-death capital gains tax appreciation. That's one of the big changes that a lot of people are worried about. The other is the Minnesota taxation of its residents-non-residents, where are you domiciled, and for both death tax and income tax purposes. That's been changing and is on a lot of people's minds. I suppose the third change is just it's a broad expansion of many statutes and regulations that the lawyers and accountants have to keep up with to keep their clients on the straight and narrow. They're just getting over-regulated.
Stephanie, I would add with respect to the estate tax exemptions, it's certainly a very common question that I get from my clients because one of their concerns is, will my estate or my beneficiaries be responsible to pay estate tax at my death? And so in Minnesota, we always have the conversation both about the federal estate tax and the state of Minnesota estate tax. And so when Mark was talking about it going up and up and up, at the federal level, the exemption per individual is now over $5 million. And so the reality is that for the vast majority of the population, that won't be a concern. Their estates are not large enough to incur any estate tax. And an interesting change in Minnesota that has been phased in over the last few years is that for a long time, the Minnesota exemption amount was at $1 million. And they are increasing that in a phase-in of $200,000 per year until the year 2018, when it will be $2 million per individual. So there again, that only impacts a relatively small amount of the population. So it has made at least some of the estate tax planning simpler for many people.
All right. One more caller question here. Amy, this person has a will from quite a few years ago. Their attorney has since retired, so this person called a new lawyer about updating the will. The new lawyer said that just because the individual signed the will, that does not mean that the individual will automatically avoid probate. The caller wants to know if that's right because they thought that having a will meant that probate would be avoided.
That's a common misunderstanding that people have. I would say based on what you said right there, the new lawyer gave the client the correct answer. Probate, having a will does not determine whether or not a probate will be required. If Jenny made a comment earlier about whether somebody died testate or intestate, a person's estate may be subject to the probate court whether or not they have a will.
You can have the prettiest will and there's no assets to probate. They all pass by joint tenancy.
Okay, and with that, that's all the time we have. I want to thank our panelists for sharing their knowledge tonight. Remember, you can watch this show again online at www.wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we answer your questions about mediation and arbitration. I'm Stephanie Balmer. Good night.